Afternoon, ladies and gentlemen. The South African Bar Association welcomes you to yet again another of its week's programs. This week's program's agenda is as follows. The welcome will be given by Advocate Ishmael Siminye SC. Thereafterwards, an address will be by Judge President Mlambo. Subsequent to that would be a question and answer session, and following which, a closure by Advocate Ishmael Siminye SC. Over to you, Advocate Ishmael.
Let me say my thanks to you, Ahmed, and also say hello to the Judge President, more importantly. Also say hello to all colleagues and those that are listening to us. Thank you. Well, as you correctly say, my task is really to do the introduction of the Judge President, and am I on your screen now?
Yeah, we can see you, Advocate Siminye.
Yes. The President, I have the singular. It is, and I suspect more than anyone else, you'd be the one to know, talk about you. As I say, it's a singular privilege because I can tell the rest of the world now openly that our lives intersected at TEFLOP, as it was called at the time, now the University of Limpopo. I won't just announce what year those were. It might be too revealing about our age. But again, I can say that I can brag that you were a classmate. I was a classmate of yours and have known you ever since. Well, JP, you would know, and everybody would know that you are sitting as the Judge President of the highest and the biggest division of the High Court in the country, which is Gauteng. And your history is so long that if I started to speak about your curriculum vitae, we'd probably exhaust the entire opportunity of having your bright mind on the lecture. So I'll just say a little few. In those days when we were classmates, the university was very proud to have you run for the university in the intervarsity competitions. And they must accept my word that you are an incredible sprinter at the time, doing 100 meters and 200 meters. And the university was proud to have you in that capacity. But that was a long time ago. Now, I have also had the privilege to sit with you at the Judicial Service Commission. And we can claim the attack and the adulation for the judges that we have. You sit there in your capacity as the head of the Gauteng division, and that's how I know you. But South Africa knows you better for all the judicial work you have done in the years and all the pre-judicial work you have done with the LRC and with the Labor Court. You were the president of that court when it started. Well, you were in that division. That's why you started at the Labor Court before you came to be a judge in the High Court. And later, as we say, the Judge President of the division. Allow me also to say that you also were sitting as a chairperson of the Legal Aid South Africa, which is assisting indigent people in accessing justice when they come across the law. And in that, we also know that you are sitting as a trustee as well of the LRC, the Legal Research Center, which was and still is one of those vibrant movers in protecting the constitution of this country. That is how I think I know you and want to introduce you. Of course, today it's a different engagement at the invitation of the Bar Association of South Africa. And I want to thank Advocate Bart Ford, who has invited you to be part of this discussion lecture, afternoon exchange on the topic of the virtual hearings and the future of litigation. Of course, with COVID now, the world has changed. We no longer litigate as we used to do in the past, and we will hear a little bit more about that and your prediction about how the legal landscape has changed and will change and look as we go forward. I introduce you.
Thank you, Advocate Semenya, for that kind introduction, and good afternoon, Advocate Ford, to other members of the leadership structure of this bar that has invited me this afternoon. And Advocate Semenya, I can confirm most of what you said. I don't know why you didn't tell them what you used to do yourself on the football field, but that's a topic for another day during our student days. But Advocate Ford, thank you very much for inviting me. I know this is the second time that you wanted me to come. The first time I couldn't make it because I had short notice. And I'm here today. I hope just to talk informally and generally about my experience under the pandemic and running this division, about how we had to adopt, and also touch briefly about what the future holds, you know, having experienced what we're going through as we speak. As Advocate Semenya says, the global pandemic has forced us to adapt how we work whilst remaining safe. I think that's the whole preoccupation, to remain safe and away from contracting this deadly disease. What the pandemic has done, however, has been to completely transform the way we conduct business today. You just have to look at the directives that have been issued in this court, in this division, which mirrors the global trend. I mean, globally, a lot of other courts have also followed suit in terms of trying to direct how their proceedings have to happen in line with legislation that's aiming at making sure that its citizenry is safe. So, in a nutshell, the pandemic has placed a significant amount of pressure on legal systems in particular to embrace technological change. Now, when I mention that, you just have to scout around and you'll see how many webinars are taking place that are talking about courtroom practice, you know. So in all this that's happening, there's an elephant in the room, as they try and say, those who know the Queen's language better. And that elephant in the room is that the legal profession, I'm a judge, I'm a part of that profession, is always the last to embrace transformation. And I have seen how adapting to the onset of the fourth industrial revolution has been a big challenge to the legal profession. Judges and lawyers are the same. When it comes to embracing transformation, especially technological transformation, it becomes a problem. We can talk about this later. As I said, I just want to talk informally about virtual hearings. You know, I don't have to repeat this, that courts are there to resolve disputes and deliver justice to litigants. Virtual courts provide for the hearing of matters with the judges, lawyers, and litigants at remote places, that is, at different locations from each other, but real time. The communications amongst everyone are conducted over electronic networks that permit interactive data, voice, and visual transmissions. Because of the pandemic reality and the need to safeguard court personnel from contracting the disease, as well as ensuring that the litigating public is also safe, we took some policy decisions in this division regarding our workload as to how we are going to continue with our work and ensuring that we remain safe. And one of the biggest policy decisions we took was that paper-based work like applications and appeals could not be done physically. Those were the prime targets, as I say, for digital and virtual dealings in our courts. Paper-based matters are, especially in this division, the complex spatial motions. They are called the third court matters in Pretoria, and they're called special motions in Johannesburg, as well as in normal unopposed and opposed motions and interlocutory applications. Case management conferences were initially not targeted for virtual hearings, but they were also added later as they are also paper-based. But the biggest challenge that we had to confront was how do we run civil trials and criminal trials on a virtual platform because of the need to safeguard the integrity and fairness of the proceedings, as well as evidence management. These were slow to take off, that is especially civil trials. They're slow to take off because parties were anxious that wherever a witness may be, he or she may be influenced or coached, and nobody would be there to prevent that. So these were some of the dynamics we had to tackle, and they remain relevant as we speak today. And talking about civil trials in particular, most of them take place virtually, but criminal trials are about 100% in in-person hearings. There are also paper-based matters that also take place in person. That's chiefly determined by either the judge, but in most instances is the legal representatives who insist on in-person hearings. You won't believe it, Advocate Ford, how many times I've got to deal with very vocal legal representatives who insist on in-person hearings, despite the fact that everything is paper-based and everyone has access to virtual platforms where the matter can effectively be dealt with. Talking about what's happening currently, I'm also aware that alternative dispute resolution forums have continued to run, probably at full functionality, I think, during this pandemic period. I've witnessed one presentation by one of the mediation forums around, which showcased its online mediation platform. And it looked so good and so simple to navigate around that I would be surprised if anyone would not want to embrace online mediations. But I also hear that arbitrations are also being held virtually. So this is the adaptation that I spoke of earlier, that because of the pandemic, we had to embrace virtual dealing in our courts, in our court proceedings and our divisions current day. I can also reflect that in our criminal trial section, from some time ago, we did use technology. That is remote witness technology. First, it was a closed circuit television, that is the CCTV, and later video conferencing. These were used as a means of taking evidence from children or other vulnerable parties, such as victims of sexual assault, to shield them from the physical presence of the accused in the courtroom and the risk of intimidation. So, pandemic or not, we've always used this. And I say this specifically to say those who may be agitating that when the pandemic is done and dusted and gone, we should go back to full in-person hearings. We shouldn't ignore what we've had even before pandemic days. So while it is this CCTV program in criminal trials, while it is still being commonly used to enable vulnerable witnesses to give evidence from a location outside the courtroom, there are judges who have utilized video conferencing now in terms of enabling other normally bodied witnesses to give evidence from localities away from the courtroom for a variety of other reasons. I know of one long-running trial in this division where the judge presiding in that matter has had to adopt a hybrid process of hearing the evidence of some witnesses remotely whilst hearing some of them in court. And in one of the hearings that he scheduled in that matter, one of the accused persons was actually participating in that trial remotely. So I have also, because I have an interest in this field, I've also witnessed how digital judicial processes work internationally, especially in Malaysia and Singapore and the US and in the UK, where I have friends. But I don't want to talk about those. I just want to stay with what's happening here at home. So in addition to the processes I've described in this division, which are subject to directives as to how matters are to be handled remotely, I know that remote consultations are also being used and accepted as the norm. Whilst it is preferable to have face-to-face consultations, the pandemic has seen remote consultations become the new normal, as I say. And this is in the interest of preserving health and safety and maintaining social distancing. So from a technological infrastructure point of view, prior to 2016, courtrooms were not Wi-Fi enabled. I mean, why would we have wanted to look at it? But the pandemic has told us that's the way to go, and that's the future. Today, I know that in Gauteng, at least, courtrooms and the buildings in general are equipped with technological infrastructure that enables the court to deal with its work using the case line system, as well as using virtual platforms. And our main virtual platforms that we use as part of government are the MS Teams platform, but we also use Zoom, despite what people say about its security. I use Zoom personally, and I've not had any problems. But we've seen other courts migrating to virtual hearings. I mentioned here the Supreme Court of Appeal and the Constitutional Court. We've all seen and witnessed those two apex courts run their proceedings virtually. So having sketched this very brief experience of how we've had to adapt in dealing with the pandemic, but in making sure that we continue our work, what's my thinking then about the future? And I think that's why we have this discussion today. My view is, I think post the pandemic, it will be counterproductive to revert to in-person hearings fully, as if nothing has happened. I think you will also agree with me that virtual platforms come with efficiencies we don't have in in-person hearings, right? It may differ. I mean, from a court perspective, we may view some of the consequences of using virtual platforms as efficiencies, whilst from a practicing legal representative's point of view, this may have other inroads in terms of how that legal representative goes about conducting practice. But I want to believe that the usage of virtual hearings and combined with case lines has presented a few advantages, as I say, advantages and efficiencies. The most obvious example is the reduction in travel costs. This has assisted people with hearing, vision, mobility impairments, or other problems from obviating the need to travel to the courtroom. I mentioned the issue of expert witnesses. They no longer have to come to court, but this is all based on parties agreeing that those expert witnesses can testify using a remote platform. Often we've seen trials being postponed because the expert, for one or other reason, has not been able to travel to the courtroom, or any other witness. But the fact is that expert witness or a normal witness is available and can be enabled to access a virtual platform properly Wi-Fi enabled and participate in the court proceedings. So saving time for many people, including the judge, legal representatives, and witnesses, has been one of the biggest advantages of using virtual platforms. And this has also improved the trial calendar in the sense that sometimes you find matters being crowded out because there are insufficient courtrooms. But using a virtual platform means you don't need a physical courtroom to do your work. I just want to mention another big advantage that we've seen in this division. You all know, practicing here, that in the urgent court trial role, you have 2 judges who have to deal with the workload there. But when you deal with after-hours urgent court proceedings, these are conducted virtually and on case lines without the necessity of court officials in particular, judges, as well as litigants, leaving the safety of their homes and traveling to the court. So that's one of the biggest advantages of using virtual platforms. Motion proceedings and appeals have proven to be the most ideal case areas to be used for virtual hearings. Motion proceedings and appeals can be used because they free up necessary courtroom space and enable that those matters that require in-person hearings do not get postponed because of the unavailability of physical courtroom space. But I want to also suggest that if we embrace virtual hearings going forward, which I propagate for, I think the physical infrastructure budget of the Office of the Chief Justice will gain significantly, because the need to continue building courts, court buildings, courtrooms will have to be revisited if proceedings can be dealt with remotely. And I want to suggest that the curtailment of paper-based litigation is environmentally friendly, because the need to print and use actual paper aids this objective. I don't want to pretend that there are no disadvantages to using virtual hearings or virtual platforms. I mean, one of the biggest that has been quoted is that virtual hearings have interfered with the transparency of the justice system, in the sense that when you use a virtual court sitting, only the litigants and their legal representatives and the judicial officers are privy to the proceedings. Although we are trying to address this by ensuring that we generate a link either on YouTube or on these other social media platforms to make sure that anyone who is interested in accessing those proceedings does so. But this will still exclude a significant amount or number of the citizenry, because not everyone has access to those social media platforms, which also depend on the availability of funds to make sure that one has access to the necessary Wi-Fi programs. But another downside, which should be looked at closely and addressed when using virtual hearings, is the issue of witness credibility and demeanor. I mentioned earlier that when a witness testifies from a remote location, it is almost impossible to know whether that witness is being coached or whether that witness's evidence is being tampered with, because we are all sitting remotely from each other. I know that some of the bar associations have introduced the concept of witness rooms, remote witness rooms, to address this, and that is all subject to agreement. But other than these 2 main criticisms of virtual hearings, I want to suggest that having identified paper-based matters like appeals and motions, and recognizing that the need to use in-person hearings to deal with these matters is obviated if all the parties in the matter are agreed that the matter should be dealt with remotely. So the thinking in this division is that the learning that we have gained in using virtual platforms in dealing with our work should not be forgotten when we come back to normality. That is hopefully when the pandemic is done and dealt with sufficiently. I think what I have mentioned is that there are gains and there are efficiencies and there are advantages of using virtual platforms. And I would want to think that legal practitioners must also adapt to conducting practice as they're doing it now, because the virtual platforms have shown us that we can still do our work, we can still fulfill the aspirations of our clients, even though we're dealing with our work virtually. So I would want to hear from the people who are attending this meeting as to what they think in terms of going forward. I know that most of the proceedings that are done virtually are provided for in terms of the practice thereof in directives that have been used. But the directives are a temporary measure. They are temporary in the sense that they are all based on the continuation of the pandemic and supporting government in ensuring our safety. But when the pandemic is gone, we in this division are of the view that we will embed some of the good practices we have introduced in running virtual court hearings in the practice manuals of this division to make sure that we don't lose the learning that we have learned. So I know that the issue of virtual hearings and I suppose digital litigation threatens some jobs. I mean, we all know what happened when Standard Bank was confronted by industrial action from its staff members who were threatened by job losses due to the introduction of technology in the courts, in the banks. We've had some taste of that in the courts where court messengers wrote an open letter to me as JP of this division to say I must stop case lines because case lines is threatening their jobs. But I want to think that legal professionals who run big firms and even the advocates professions who have other support staff can undergo reskilling programs to make sure that people who are not properly skilled to interface virtually or digitally can be reskilled to continue supporting the legal profession whilst operating on the digital and virtual platforms. So I want to propagate very strongly that this is an important phase in the history of legal practice, and we should not dispense of everything we have learned. The good practice matters that we have identified as to taking court processes into the fourth industrial revolution must continue, and that we will enjoy some savings. I mean, I've mentioned the physical infrastructure budget of the Office of the Chief Justice, but there are other low-hanging fruit that may be identified in terms of ensuring that we continue our work, we do not contribute to job losses, but we continue to operate on a changed platform. I think I want to stop there because I've been talking for some time now, and just deal with whatever questions and comments that can be raised against me, because I think this is an interactive platform. I just had to make those comments before we engage each other. Thank you very much, Advocate Semenya and Advocate Ford.
Thank you so much, JP. Thank you for your time, as always. Thank you, Advocate Semenya. Perhaps, Advocate Semenya, I'm not sure whether you can see the questions that were raised in the chat box. Are you able to?
Yes, I am. Thank you very much. Advocate Ford.
Please, can you take us through the questions in the chat box, please, Advocate Semenya?
Say that again, sorry.
Please, can you take us through the questions raised in the chat box?
Or what I didn't do is to record each and every one of them. So I don't know how we correct that.
I can see them, Advocate Semenya. Clearly,
right.
me and you, the way we've been trained in interfacing here is different. I think the
Yes.
first question that's on the chat room is from Hasina Kasim, who says, how do we deal with a judge who insists on an in-person hearing where there are many parties and the risk of a crowded courtroom? That is a very real challenge that I've had to deal with. The unfortunate part is that when these instances happen, the matter has never been escalated to me. I think it's only in one matter. It was a criminal trial. And you know that I've issued a directive that mentions how many accused persons. If you've got accused persons in custody and on bail, those matters should not take place because of the risk of infecting each other, unless all the accused persons are either in custody or on bail. And that also deals with how many people who attend the courtroom, including legal professionals, witnesses, court orderlies, are allowed to come into the courtroom. I've had the occasion of some judges wanting to continue, irrespective of the numbers. And where those matters have been, as I say, one matter was escalated to me and I had to speak to the judge, right? But you see, the downside of doing this is, from where I sit as JP, you have some accused persons who've been in custody for quite a long time. Most of them, the norm is about 3 years and above in custody. And if you continue postponing their matters because you are scared that there's a risk of infection, you are actually condemning them to further processes or periods in custody without their matters being finalized. So that's a counter suggestion. But I have made it my mission to say to judges, the risk of infection also attaches to them as well. But where the numbers far went beyond what the directive says in this discussion, and the parties were agreed that they are prepared to continue, I've had to give my permission that those matters continue. And touch wood, we've not had any judge, I think in the last, from the second half of last year, contracting the COVID-19 virus. And you know that the criminal court judges sit daily in in-person hearings. So what they tell me they do is they make sure that there's proper sanitization, they spray the courtrooms and ensure that the social distancing aspect is looked at. So I hope I'm answering your question correctly, Hasina Kasim, to say, if the courtroom is crowded, seriously crowded, no judge in his right mind would be doing a good thing in insisting on the matter proceeding, because a crowded courtroom is a recipe for serious infection, right? So I think that's my answer to that question. But the next question is, it's a comment. It says, virtual hearings are an excellent idea, I suppose, going forward. Besides time and cost saving, it will prevent prisoners from escaping during transit. My comment to this is, and this dates back to the times before the pandemic, we've got what we call the AVR system. It's the audiovisual remand system that was introduced by the Department of Justice some 11 or so years ago. But it's a remand system. It's not a trial system. We used it very productively as a high court, even though none of our courtrooms are equipped with the AVR equipment. We used magistrate courtrooms to postpone our matters, thus preventing the transportation of people whose trials were scheduled to take place from not coming to court, but dealing with their matters there. But the thinking is that this AVR system should be developed further to become a trial system that is enable a trial to happen remotely, not just to postpone a matter. Let me
before attending to other questions in the chat box, there is a question by Ahmed Jassat, who's raised his hand. We'd like to take his question, and thereafter a question from Advocate Romian Tabaleni. So can we have your question, please?
Thanks, Paul. Firstly, JP, during my telecom with your secretary yesterday regarding the facilitation of today's program, Nolene informed me that she had calendarized today's program within your diary, attached with a link. I paused and I realized that JP's diary is not just an ordinary diary, it's an electronically linked diary. As the saying goes, lead by example. In lieu of your exceptional address today and your linked diary for that matter, you are most definitely leading by example. However, we are getting there, JP. We are getting there. Now, going to my question. The COVID-19 pandemic has indeed been the catalyst needed to direct the country towards paperless digital courtrooms, which will allow presiding officers and legal practitioners to work more efficiently and effectively in a secure online and virtual environment. Tapping into technology can only improve the role of the courts as guardians of South Africa's law, or rule of law rather. With that said, I am sure that you would agree with my submission that such technological revolution is highly, alternatively put solely, dependent on our country's technological infrastructure, naturally that being provided by the various data providers. Albeit the fact that the various data providers are doing all that they can, their services come at a cost, and a substantial cost for that matter. According to a report by Cable, South Africa ranks 148 out of 222 countries on the price of mobile bandwidth. We have to be cognizant of the mass population of this country who simply cannot afford for such. Furthermore, by extending on my question, alternatively put, shining light or the lack thereof on my question, it is an undisputed fact that our country, and Gauteng for that matter, has and is currently experiencing load shedding, which would significantly further impact on those that have access to data. According to Judge President Mlambo, what is your submission in relation to the legal sphere's dependency on the technological infrastructure in lieu of, one, the cost implications to those who cannot afford for such, and two, the load shedding implications to those who can?
The load shedding part, I'm not sure I can deal with it unless I want to be controversial. So I don't think I want to venture that far, but it's a reality that when load shedding happens, it affects some of the mobile platform beacons that are there. I know when I'm sitting in my house, I mean, I decided to come to Chambers today because I know we had scheduled load shedding. So when we have load shedding, even if you have 4G enabled Wi-Fi connectivity, because the beacon does not have a battery that will bring the mobile network closer to you, I can't continue. So that's a real problem. I think that ESCOM has to address that meaningfully in terms of how it capacitates itself and eliminates load shedding going forward. The cost of data is another reality. You are correct. And we've not been unmindful to that. That's why we allow anyone who wants to participate in our virtual court hearings, especially unrepresented litigants, to come to the courtroom, and they are directed to their own virtual courtroom where they can participate without representation, but being assisted by court officials to participate in the court hearings. As far as the legal profession is concerned, I think my suggestion has been clubbing together and creating virtual connectivity rooms by the professions could assist those legal professionals who are struggling financially in terms of ensuring that they participate in their courtrooms. But the downside of that, however, is that they will still have to travel to their chambers for them to participate meaningfully in court proceedings. But that's an ongoing issue that I think the legal profession can wrap its heads around and see how they can assist each other in ensuring that people are able to participate meaningfully in these court proceedings. I hope I've answered that question.
Thank you, JP. There's a question from Advocate Ntabeleni.
Good afternoon, JP.
Hello, Advocate Ntabeleni.
Thank you for the presentation. What I would like to to submit, JP, is in relation to the reconfiguration of the rules of advocates and people that are appearing in courts. I will deal with that in detail with Advocate Ford, because what has been happening since the opening up of this virtual space, JP, is that we have seen the judicial officers being abused by practitioners that are appearing, like ourselves and other advocates, where you will hear that a practitioner will be asking a judge if the judge is properly robed or if the judge is dressed or is wearing tracksuits. And in the benefit of an open court where there are problems being encountered by counsels, you get your colleagues and senior colleagues to try and call you to order and assist you. But when you are alone, sitting in front of your computer, things can actually easily go out of hand, JP. So I wanted that issue to be addressed relating to the conduct of practitioners when they are appearing in virtual courts and the court etiquette and the rules relating to that. And in relation to what you have stated relating to the future, I have to be honest, I was a skeptic before of the virtual platforms, but having experienced them and having encountered them myself, I believe that indeed this is the future. And one American artist rightfully said it, I just forgot the name of the artist who said, if you live in the past, you will never last. So that is the position. So I want you to address that one of the etiquette of the practitioners in addressing the judges and the decorum of the court, because that should be kept and that should continue, because the new practitioners will not have the benefit of having a real court experiences and observing seniority, not standing up before your seniors and things of those nature, JP. That's my submission.
Yeah. Well, the issue of disrespect of judges and judicial officers is an issue that has come to the fore. And I can confirm that yesterday I had a meeting with the LPC, and as JP of the division, we were discussing a number of issues, that one included. And we agreed all round in that meeting that this is an issue that needs to be tackled, because the fact that legal proceedings are virtual does not mean that they are less than formal. They remain formal. And if you've studied the directives we've issued in this division, we deal with the issue of court decorum and court etiquette. And those legal professionals who've misbehaved against what the directives say have been reported to the LPC for them to be dealt with. So it's only how the LPC deals with these matters going forward that will ensure that the decorum that we all want and aspire for in our courtrooms is maintained. I think that would be my response to that, Advocate Ntabeleni.
JP, if I may just pick up a question in the chat box. The question is, understandably, pupils who undergo pupillage as part of the requirement for them to complete their competency assessments need to attend a number of court trials, number of motions, etc. Understandably, so the question is, they would not have that experience, and how could one compensate for that?
That's a very valid concern. And the way we've tried to address it, I think we've addressed it regarding access by members of the media to our proceedings. And I think the directive is clear that if anyone is aware of a matter that's coming up, they can send an email. I think Nolin is the one mentioned in that directive. They can send an email and she will facilitate access to the proceedings via the secretary of the judge. Or if the parties know the judge who's sitting, and they can send the email to that judge's secretary. So with regard to the bar, I have a very good working relationship with the bar, even though Advocate Ford, I've never met you guys and your executive formally. Maybe we should do that, because I have a relationship with all the leadership structures of the bar associations. And we agreed ways of how we can deal with each other. And this one that is raised about how pupil advocates can access court proceedings is a very valid one, because it's easy for my court or even my office to can populate a notice regarding upcoming trials, as well as a link that has been generated regarding access to those matters to be sent to the bar associations for the pupil advocates to can link into those proceedings and observe. And that's easy, it can be done, you know, and I can give you that assurance now that we can do it and we will do it.
And JP, there's another question from Gary Myberg. I hope I'm Gary Myberg asked, would it not require an amendment to the High Court Act to enable the judge of the court to order that a trial be held on a virtual basis in the absence of an agreement?
Just say that question again. Sorry, I didn't hear the help. What does he say?
It's a question by Gary Myberg. Gary, don't you want to raise your hand and put the question about the context?
No, I can see the question in the chat box. He says, would it not require an amendment of the High Court Act to enable Judge Court to order that the trial be held on virtual basis absent agreement? You are correct, but I don't think we need to get there, Advocate Myberg, because some of us like using Section 173, I think, of the Constitution, that as courts, we are constitutionally empowered to control and fashion our proceedings as best as we see fit. But it would be neater to look at all the current legislation and see that it is made to fit with the current way of litigating, that is online platforms as well as virtual hearings. I know that the rules board is in the process of generating rules that embrace what has been happening since the pandemic struck. And that process will eventually lead to an amendment of all legislation or rules or regulations that may impede the authority of judicial officers in ensuring that proceedings take place in a desirable manner.
We've got a question from Advocate Goodenough, actually, Dollars Goodenough. She asked, if in a courtroom, can counsel insist that the judge and all the legal representatives and the witnesses and people in the gallery wear masks throughout, since this is the law?
Well, I mean, in a courtroom, the proceedings are under the control of the judge. I would imagine that if counsel who is participating in a virtual hearing wherever he or she is can make a submission that people participating in that proceeding wear masks. But I would struggle to find the basis for such a submission if we are all sitting virtually. Where we are sitting physically, I've seen and I've participated in physical court proceedings regarding the Disaster Management Act, where throughout the proceedings, the judges and the advocates have been wearing their masks. They would only take their masks when they are talking, but other than that, they wear their masks. So I think it depends on what's happening on the context of what motivates that request by counsel.
Yeah.
There's a question from Neris asking, I heard that the appeal judges deliver written judgments. This affects practitioners as they are unable to bill for the court appearance. Can this be addressed?
That's a self-interest legal professional question. But the directive is very clear that to avoid contact, minimize contact and minimize the risk of infection, when judges finalize their judgments, they simply upload it and email it to the parties. I think it will be counterproductive to say that judges must now insist on a formal appearance by advocates who want to note judgment. I know that there are problems here and there about judges' secretaries not uploading and sending by email the judgments that have been handed down, but I don't think it goes hand in hand with our attempt to make sure that we avoid infection by insisting on people, advocates coming to court to note judgment. Unfortunately, I think the profession must take this as a reality, that it goes hand in hand with the virtual dealing that we're seeing in our courts.
JP, it appears that most of the questions that were put have been answered either by yourself or in relation to your responses to other questions. I'm going to hand over to Advocate Ishmael Semenya, SC.
But can I just respond a little to what JP just said about the judgments handed down?
Yes.
What I meant, Judge, is that can the judgments be delivered virtually because they handed down and it prevents practitioners from billing for it? I think Judge will recognize me. I was with the DPP's office. I'm now at the bar.
I now understand the question. So you're saying when the judgment is ready, instead of it being emailed and uploaded, the judge should convene a formal virtual hearing and read the judgment into the record. That's what you're saying?
Correct, Judge.
Which will mean that the legal representatives involved in the matter will have to attend that hearing for them to be able to charge. I think it goes against the cost-saving element of virtual hearings, but if the bar associations feel very strongly about this, I don't see judges refusing to do it. I think it's a further dig in the pockets of your clients if you want to attend formal hearings and no judgment.
Judge, it's not only with regard to the bar, also the Legal Aid Board seems to have a problem getting practitioners to do their work because of the lack of being able to claim for not appearing.
Yeah. That's fine. Look, we're approaching the end of the term, and I think I'll table this in the judges' end of term meetings and ask what their views are about convening formal virtual hearings for purposes of handing down judgments.
Thank you,
I'm
Judge.
not putting that here. I think I will table it there. Yes.
Thank you, Judge.
Judge, please spare, Judge President, just spare us a minute or two. There's a very important question by Ross Shepston. Ross is asking, after saying thank you for your leadership in the digital transformation, after the pandemic, asked Ross, will the practice manual set guidelines for the hearing of matters on a virtual platform, or will it be at the whim of the individual judge?
In fact, I think I mentioned this, that all the directives now are pandemic linked. But as I say, we've gained insights as leadership in the judiciary that there are practices that we need to retain going forward. And that once the pandemic goes, we will amend our practice manuals to embed some of the good learning that we have acquired over this time to make sure that we carry forward with how we do certain things on a virtual platform. So yes, it will not be at the it will not be the whim of any individual judge that determines what happens. These will all be in the practice manuals.
And then lastly, Judge, before I hand over to Advocate Semenya, the question is, if Caselines is an online platform which is in essence public, should the press not be given access thereto? We're thankful that members of the press are in fact part of our audience, and I submit that would assist them in accurate reporting and or reporting on matters of public interest?
Yes. Well, we've issued a directive saying judges, when approached by members of the press to be given access to the case lines folder, they must. And I know that it happens. I've had to deal with about 2 cases where judges refused to allow members of the media to have access to the case lines folder. And I've addressed that. You're correct. Whether a case is physical, it's a public record. And whether the case is on case lines, which is the digital format, it remains a public record. And any member of the public, including members of the press who want access to that case, must be given access to that case.
JP, thank you so much. I'm handing over to Advocate Ishmael Semenya, SC, and we accept the invitation to meet with you. We'll set it up with Nolene, and our team will come through and meet with you and have tea with you in the not too distant future. Thank you, Advocate Semenya.
Hi, Advocate Ford. Again, perhaps before we conclude, I just wish to contribute another perspective to the discussion. Some of us who started practice before the pandemic have really acquired an extensive professional development by associating with seniors in our midst. And that way it gave us access, JP, to have an opportunity to be personally engaged with the luminaries in the profession and develop our profession. As I hazard a guess that those who are now entering now in the virtual space have no opportunity of that professional development, which is encouraged by meeting people personally in chambers and exchanging ideas and their development. What would be your reaction to that?
Yes, I think it's a valid point to make, Advocate Semenya. In fact, a very good illustration of what you're saying now, if I understand you well, is I think Advocate Ntambeleni will tell you he finished acting in the last term here in this division. Almost all the acting judges, especially the first-time acting judges who act, they mention one point, that they miss the in-person contact with permanent judges. And that deprives them of the development you're talking about. Because when we are all here, we meet at tea, or you sit next to someone in chambers, you simply stand up, go knock in chambers, you sit, you discuss. We miss that. And I would imagine the way you practice law now, the recent incoming people into the profession are missing that. And I think it means that we need to put our thinking hats on and see how we address it. What I've done in this division has been to try and when someone acts, they have access to a folder on case lines. That folder contains the contact details of all the permanent judges, including their cell numbers, and that you are able to can look at that folder, get the number of the judge you want to talk to. And I encourage acting judges to be in contact with judges so that you can call and you can agree to meet. I mean, if there's 2 of you in chambers, you're not violating any disaster management regulations, but you can even talk virtually. We connect. When I meet my judges, 1 or 2, or with the DJPs, we hardly ever meet in person. We connect virtually. But it's a valid point you are raising, Advocate Semenya. It affects development if we continue to operate virtually, because you develop anti-personal tendencies. I mean, we try in this division to schedule a virtual tea time. You know, you sit wherever you are to have tea, but to connect with other colleagues. And it's a problem because those sessions are not attended fully. So one judge was actually saying maybe we should take a risk and schedule an in-person tea room meeting and see how many judges respond to that and see how we can control it. But it's a valid concern. It needs to be addressed. I agree with you.
Of course, our responsibility, JP, to reduce the carbon footprint, which is also another looming opportunity for all sorts of things. I still recall that in the 80s and 90s, trials like the O.J. Simpson trial was already paperless. So there is no doubt in your speech to tell us that the new normal is going to explain the rest of our future and impact on it differently, but the law is not only the area that is going to be impacted upon. I must, in conclusion, JP, thank you very much for your leadership as well. And thank you for the address you gave this afternoon. And the general assistance I have learned we receive from you as the head of this court. Thank you very much, Batford. You're a colleague, you are a star in your own right, and I watch what you do with interest and pride. Thank you.
Thank you, Advocate Semenya, and thank you to the people who listened to me. And I just want to assure those who asked when is case lines going to the labor court or to the magistrates court. Yes, those are subject to government budgets, but in the next 3 months, you will be seeing the introduction of what we call Court Online, because Case Lines was the second platform. It took place because it was ready and it's off the shelf, but Court Online, which will deal with all the hassles people have on Case Lines, will be introduced from the beginning of July. And then once that happens, then it will be rolled out nationally, division by division. And once we've sorted out our departmental issues with the Department of Justice, the lower courts should also be beneficiaries of online court processes. Thank you very much. Thank you for inviting me. I appreciate it.
Thank you, everybody, for attending. Thank you, JP. Thank you, Advocate Semenya, SC, and thank you to the team working with me. And we see you again next week, Thursday. Every Thursday at 4, we have a program of interest for protectionism.
Thank you.
Thank you very much. Thank you.